Hello everyone, this is MAHEK, a legal internet LEXIS and Company. Welcome back to our channel. Today I will be discussing about transfer for the benefit of an unborn person. We all know the transfer under TPA could be done only inter vivos, means among a living person. But still, what would be the conditions, or what would be the process for transferring the interest of a property in favor of a person who is not even in existence but may be in existence in the future date? So such transfers are known as transfer for benefit of unborn person, the person who is not in existence. Section 13 of TPA deals with this situation when the transfer wants to transfer the interest of the property for a person who is not even in interest, and even if the interest so created would be for the person, for the unborn person, still the general rule of the Transfer of Property Act that the transfer should be between inter vivos is preserved by this section as well. So let's start with one by one components of the section 13. Section 13 first, before starting it, first thing is who are these unborn persons? Unborn person means any person who is not in existence at the date of the transfer, but may be born at the later date. There are two types of these unborn persons. First, who is already conceived and is in the womb of the lady, and the other one who is yet to conceived and is not even in the womb. Transfer of Property Act or Section 13 of TPA covers both type of person, either they are in the womb or not. So the transferor can create the interest for both type of persons, regardless of the fact that they are the womb or not. It may be some person who may be in the existence after 10 years or some period of time, but still the transfer can be made in their favor. So now the process, the steps to be followed while making a transfer while making the transfer for such person includes. First step is the person intending to transfer the property for the benefit of an unborn person should create a life estate in the favor of a living person, and after it an absolute estate in favor of the unborn person. So what does this mean is, if A wants to transfer the interest in favor of C, C is the to be born, C is the unborn child of his sister. So for creating the interest in his sister's unborn child, A first needs to make a life interest in the favor of some living person. It may be the sister itself or some any stranger or any person. A is on the liberty to choose that person, and then after that an absolute interest is to be created in the favor of that unborn child. So then we have till the person in whose favor a life interest is created is alive, he would hold the possession of the property, enjoy the property, and if during his lifetime is that unborn child came into existence, is born, then the title of the property will, so as soon as he born, will be vested with him. However, the possession could be retained only when that the person holding that life interest is died. So it's a very simple step before granting the interest in the favor of an unborn child. The transfer needs to create a life interest in the favor of some living person, and then an absolute interest in the favor of that unborn child. So creation of a prior interest. creation of this prior interest, there is no limit for how that for only one person or for only two person the life interest could be created. It is for the A to create how many successive life interest he could create before the absolute interest is hand over to the unborn child itself. However, section 14 and it says about the rule of perpetuity. It says that such life interest could be exceeded only till the lifetime of the transferor. Means, however, since how many say regardless of the numbers of those successive life interest holder, their total still that life of it cannot exceed the life of the transferor itself. Second, that life state continues till that unborn child has not attained the age of majority, means 18 years. So then we have this absolute interest. It's a very much condition that any interest to be created under section 13 by way of section 13 needs to be an absolute interest in the favor of this unborn child. It should not be a limited interest or restrictions, interest with restrictions. For example, if A had decided to transfer the interest for the similar that the child of a sister is yet to be born, but he then said that after him the daughter of his brother. The daughter of his brother means that he had not created the absolute ownership in the hands of this child. He had given only a life interest to that child. So such situations, TPA make those situations or those clauses void. It says that until and unless the transfer of property creates an absolute ownership, absolute interest to the unborn child, it would be a void clause. So section 13. So if we summarize what section 13 says, is just very simple. If to create an absolute interest in the property or in the favor of the unborn child, the transfer needs to first create a life interest in the favor of some other living person, and then an absolute interest. The interest should be an absolute one. It needs not to be a qualified one. This was all about section 13 talking about the transfer of interest in the favor of an unborn child. Hope you like this video. Thank you.